Hello and welcome to Legalese, another version brought to you by the Northern Middlesex Bar Association. I'm Ernie Hyde and my office is in Shirley. I have with me today, once again, thank you for coming on, Jerry Decristofaro. Jerry's Director of Legal Training for the Massachusetts State Police. In November, when we last voted, November 4th, we voted on a question in Massachusetts regarding the treatment of marijuana, and a vast majority of voters elected to approve a statute that would make the penalty for possession of marijuana a civil penalty as opposed to a criminal penalty. Although many of the law enforcement people were against that statute, it passed by a vast majority of voters. So now we're able to discuss how we're going to be dealing with this, both from Jerry's point of view as a trooper and a trainer of troopers, if you will, on how to deal with it, not to mention the local police and college and university police. But how defense counsel are also going to be looking at this new statute and dealing with it as well. Jerry, let's start off first by talking about the law as it once stood, that is, how it stood prior to the implementation of this law, which will be January 2nd, I believe, correct?
That's correct.
All right. So prior to January 2nd, 2009, my experience has been that if someone was caught, and we won't get necessarily into the details as to how they were caught, but at some point a police officer found marijuana on them or in the vicinity of them and were able to prove that it was possession. If that person never had an offense before, in other words, didn't have a prior offense of possession of marijuana, the disposition under the statute was a recommendation, very strong recommendation that most judges went by. I can say probably almost all judges went by, that the charge would be continued without a finding for a period of 6 months. And what that meant was there was not a finding of guilt and there was not a finding of not guilty. It was simply continued for 6 months. And during that period of time, if you did what you were supposed to do on probation, so to speak, on a very loosely monitored probation, then the case would be dismissed. However, the second and subsequent charges for possession of marijuana carried with them both fines and the possibility of imprisonment. What is it going to be? And I should point out that our vote on question 2 in November did not legalize marijuana. I want to be very sure to point that out. Some people got the impression that it's now legal in Massachusetts to carry marijuana. It is not. The penalties are different, but it's certainly not legal. But how are we going to be treating this in the future, Jerry?
Well, just to follow up a little bit with with defining the actual statute itself. Question 2 amended created a new statute under Chapter 94C, which are all the narcotics laws. Right. It's called Chapter 94C, Section 32L. Now, 32L deals with the possession of not only marijuana but THC, which is the active ingredient, basically, right, in also like hash or hash oil. So either one of those two substances would fall under this new Section 32L. And it is no longer illegal to possess a certain quantity. So we have to, make it very clear to the viewing public that that quantity is 1 ounce or less. Well,
let's be careful how we say that. It is still illegal.
That's right. That's correct. It's still illegal to possess 1 ounce or less, but it is criminal still to possess
more
1
than
ounce
that.
or more than an ounce of,
correct.
of marijuana or THC.
Right.
And
Okay.
that and the new law impacts not only possession of Class D substance marijuana, but also possession of Class C THC. So both of those sections were impacted under the new statute, and it's decriminalized. That's an ounce or less is decriminalized, but then again, in that I agree with you, that's a very important distinction to make. We pretty much have good information that the drug use and abuse among high school students who, it's already a significant problem. And the biggest fear, I think, of law enforcement that this would sort of encourage, in a way, more use, thinking that, well, it's no longer criminal, so therefore it can't be as bad or something like that.
Right.
Which this new statute does not at all base itself on the merits of whether or not use
the use of it
is is proper, legitimate, healthy, or anything like that. In fact, just the opposite. Anyone who grew up during the '70s certainly understands that that science has really come a long way in actually telling us just how problematic marijuana can be.
And there's also debate on whether or not it's a gateway drug. I think most of the things that I have read have indicated to me that the professionals truly believe that marijuana is a gateway drug.
At the very least, it's easy to say that if you talk to anyone who's made their way to into drug addiction, especially the hardcore drugs, say they all started out with marijuana.
Right.
Now, maybe it's just that we also know that marijuana itself may not be addictive in the normal sense, physiologically,
Right.
but certainly it is psychologically, and to those who have an addictive personality, it's going to be, it's going to have that effect, just like alcohol is with an alcoholic.
Right.
Some people can have a drink and it doesn't affect them as much, or they're not going to become an alcoholic, and one drink will set them down that road. So marijuana is very similar in that way.
Right. Okay, and as far as the new civil penalties, when I say civil, I'm comparing it to criminal. Criminal I basically described earlier, but civil penalties are going to consist of what now?
Just one alternative. It's $100 fine for a civil penalty, which oddly enough, the old statute, assuming it was the first offense like you mentioned,
Correct. Yep.
Generally there was no fine, and it was dismissed after that unofficial probation period. And a lot of courts did attach some sort of victim witness fee or court cost to it.
That's true, right.
Plus, you had to take a day off to go to court, and it did establish a criminal record in that even though the case was dismissed, if you were under the old law, if it was the first offense, and someone asked you, have you ever been convicted of a crime? Well, if you at some point in time had been arrested for possession of marijuana and went through that process, and 6 months later it was dismissed, you could legitimately say, no, I was never convicted of a crime.
Correct.
However, most agencies, most employers kind of became familiar more with the better question to ask, and that was, have you ever been arrested for any type of a crime? In which case, even under the old way of doing it, you'd had to say, yes, I was arrested, even though the case was dismissed,
Right.
Being a first offense. In fact, they had to, under the statute, be dismissed. You still had to answer yes affirmatively that you were arrested for a crime. Now, under the new law, whether it be your first time that you're apprehended for possession of 1 ounce or less of that substance, or your 100th time, it's a $100 civil fine. You're never going to be arrested for it. It's police do not have the authority to arrest for it. And the fine doesn't escalate with the number of times that you're caught for it, or have any criminal impact in terms of your record. It's not entered into query, although a word of caution that it is that record, the fact that you were issued a civil citation is still going to exist on
some record.
On a record at the police department's hold.
Correct.
So I'm sure that businesses will soon be asking the question. A lot of them already do. Have you ever been cited for or had any or had, been received a civil fine, you'll soon see that question reverting back to follow up, so they can go into a police station and ask for the report or the record of the incident, we'll call it, the civil incident in that case. So there is going to be a record, it's just that it won't be found in the ordinary sense, and not a criminal record.
I think some of these companies are actually stepping way beyond what they are permitted to ask. I think you're right in what you said, and they are asking things like, have you ever been arrested, which is, as you and I both know, is pretty much a meaningless event for the most part, unless you're found guilty.
Meaningless if you're a defense attorney. It's important if you're to some employers. It's very important. I mean, if you've been
but it's a false taint on that person at that point. An arrest is nothing more than a suspicion that something has happened, and then once it goes through the process, you come up with an answer, rightly or wrongly. You come up with a guilty or a not guilty, and that's when the rubber meets the road. So to sort of convict someone at the employment stage for an arrest is kind of unfair.
It can
but they
be.
do.
It can be.
I hear you.
It can be. I mean, I'll have to disagree to one extent. Like, if you have a person who under the old way, you look up their record and you saw, say, 10 possessions of marijuana, well, you'd only see one continuing finding, and then you'd see 9 that were dismissed for whatever reason. Right. The odds of that person having been
arrested that many times,
accidentally arrested that many times for not being, guilty. For people who go through the criminal system, they're not found innocent.
Correct.
They're found not guilty. So I guess there lies the difference.
Yep. Okay, you got me on that one. I'll let that go. At any rate, there is a difference in the new law between being a juvenile, that is someone under the age of 18, and someone being over the age of 18 and being found in possession of marijuana.
A slight difference. Under the new statute, the fine is the same, it's $100. The process is the same. They'll write you a civil citation, and the payment to the city or town where the stop occurred in that jurisdiction is all the same. The only difference is if a person is 18 or is under the age of 18, under the age of 18,
yep,
then a copy of the citation along with a little letter explaining to the parent or guardian that along with that fine is going to come a mandatory program for drug abuse or substance abuse.
Right. Which doesn't exist yet.
Which doesn't exist yet, yet.
Yeah.
So, which was another problem in the statute. It imposed something's going to cost some. Who's going to pay for the program? That's another.
Well,
that's
you know who's
issue.
going to pay for it. You know who's going to pay for it.
Taxpayer, you mean?
No.
Ultimately, legislation, I'm sure, will take care of that. That the cost of the program is going to go to the person who's taking it, and it rightfully should be. It shouldn't come out of taxpayers.
Absolutely.
Pockets.
So, the statute, as it's called out today, says that if you're under the age of 18, you're going to pay that $100 fine if you take this program, yet to be defined, and the cost of which is yet to be defined, within a 1-year period of time. Mm-hmm. If you don't take the program,
then
the fine goes to what?
$1,000.
$1,000.
Yes.
And I might point out at this juncture that there are no number of times when this escalates or stops, for that matter. Mm-hmm. So if you're caught with marijuana 10 times in a year, you're looking at $1,000 worth of fines minimum, unless you're under the age of 18, and you could be looking at how much? $10,000 if you don't.
Minimum.
Right.
Because you're going to pay for the program too, ultimately.
Exactly. And whatever that's going to be, and I haven't seen a program.
And the $100 fine, so it's $11,000 plus the cost of the program.
Yeah, and I haven't seen a program in Massachusetts cost less than $500. I just haven't seen one.
Well, I guess there'll be a cottage industry coming up.
I guess there will. And we don't know how long this program is for, and we don't know what the contents of that program is, based upon the law as we voted on it, correct?
DYS will be the agency that will,
Put it together.
that's, at this point in time, is delegated with that responsibility.
Okay. Under the new law, there is no penalty, and I want to be careful about this, there's no penalty that would result in incarceration for possession of under an ounce of marijuana, an ounce or under of marijuana, correct?
That's correct. It's because only a crime can result in any type of period of incarceration. Since this is not a crime, then there's no possibility of incarceration.
Okay.
All right, maybe this is a good point in time to mention that there are a lot of circumstances where an individual could be caught with less than an ounce of marijuana and still charged with criminal violation in 94C. And that is if the officer has an indication that the person manufactured, produced, distributed, shared, then it raises to a level of criminal responsibility under Section 34. So,
And that hasn't changed.
that hasn't changed. That's exactly the same as it always was.
So one of those, well, a number of those issues when an officer finds that ounce or under is not so much that it's an ounce or under, but how it is one package, perhaps, in minor amounts, which probably is a joint or two worth of marijuana, whatever that turns out to be in grams. How much money the person's carrying on them, whether they have a scale. I mean, all of the things that go into possession with the intent today
That's right.
go into possession with intent tomorrow, ounce or no ounce.
Right.
So it's possible that someone carrying an ounce of marijuana in 10 different bags could have an issue to worry about.
The way it's packaged, police are trained to investigate further, not just to take what they see and assume that there is no criminal investigation. In fact, search and seizure as a whole is, at the present time, we're going to be operating under the presumption that it was probable cause, say, to search, say, for example, a car based on the smell of burnt marijuana.
Correct.
Or even, in some cases,
Unburnt.
unburned marijuana. And search, and that falls into the category of what we call search and seizure, and that will still be the same. If an officer comes across a person driving a motor vehicle, let's say smoking a joint, he's going to be subject to a full search, as well as the car, for further contraband, because it's still contraband.
Correct.
Not only that,
Correct.
but even though the smoking of the marijuana may not be a criminal offense, let's say he is caught with only one joint, he or she's caught one joint, they're still on the hook for operating under the influence of a narcotic or drug at that point. It doesn't change the criminal liability or the liability, I should say, with relation to the responsibility for driving under the influence of either alcohol or drugs.
Right.
So that's impact. It has no impact on that, be it small amount or more.
Yeah.
So.
The other very important thing to remember, if you are listening to us and you are a marijuana user, and you have possession of marijuana on a regular basis, is the standard of proof now has been reduced significantly. It is no longer a standard of proof beyond a reasonable doubt to convict you of a crime. It is preponderance of the evidence.
In a lot of ways, I think this is going to make it easier for police to certainly prosecute civilly, not criminally, prosecute these offenses, in that from now on, we're not sending all these joint or small amounts to the lab. In fact, the crime lab won't take anymore. It's not evidence of crime.
Right.
Unless it's attached to some other type of crime that comes as a result of it.
Right.
There will be no lab analysis, which means under the old system, your defense attorneys would always demand a lab analysis to make sure that's one of those things, those little procedures that you had to make sure you had to make sure that it was marijuana. Now the officer's opinion, based on his training experience, is going to be determinative in that it was marijuana, no lab report needed, and in that the amount was again a guess, less than than an ounce or less.
Right.
If the officer does decide to go to challenge, in his opinion, he feels that that it was more than an ounce, of course, then it would have to go to the crime lab and be analyzed and then go through the regular course of events that we had in the past.
Now, I'd like to also point out that an ounce of marijuana, which I was shocked to see, is a fairly significant size baggie of marijuana, like a 3/4 plus full sandwich bag of marijuana.
It is
in that area.
That's a good description.
It's a lot of marijuana.
It's a pretty well packed sandwich bag of marijuana, and depending on how it's further broken, if it's like rolled into joints, it could be a number of real fat ones, or quite a few smaller ones. It is kind of I don't know where they came up with the 1 ounce. I guess somewhere, I'll have to guess, somewhere the authors of question 2 thought that 1 ounce or less was personal use and 1 ounce or more was not. How they arrived at that, though, I don't know.
Right. I had extensive conversation before the show with Brian Gill, detective from the Air Police Department, who told me that typically speaking, an ounce of marijuana was at least a week of a heavy user's supply. And if that's the case, that's significant. That is significant. So, word to the wise, if you're carrying more than that, you're probably not just smoking it. You're probably doing something else with it, and you better be careful. The one thing that we don't know yet, I have contacted the registry on a number of occasions and have not got the answer back yet, although the law does spell out that there will be no registry implications for the straight possession of an ounce or less of marijuana. I'm not sure what the registry's position is on this yet. Prior to this, however, a guilty finding of possession of marijuana was a 1-year loss of license, no matter where that marijuana was found, whether you were in a car or walking along a beach. It was a 1-year suspension. And again, the law as we voted it indicates that it is not going to be an action for the registry, but I haven't heard from them. Have you?
That's correct, yes. The registry will no longer, the way the current law is in effect, whether or not legislative amendments to it in the near future change this will remain to be seen. In fact, there are a lot of legislative changes that could impact this bill significantly over the next few months,
Right.
because of a number of the problems that came about as a result of the unique way this question 2 became law. I think most people probably realize that most of the time we have a legislative body that creates laws, and they do it in a very contemplative way. They have hearings where they have a number of different people, subject matter experts, come in and talk about the impact and the process and the logistics of it. This question 2 didn't come about that way. It came about by an author or a couple of people who didn't consult with with anyone else like the legislative process would have.
Right.
And now there are a number of legislative fixes, if you want to call it, to just the logistics of it. I mean, I don't think anyone in government can deny the fact that there was a referendum that the public clearly put forth in question 2. But I think most people will admit that they really didn't know what the details were as a result of it, and how it's going to be enforced, or aside from the general spirit of the law.
Do you think, given your experience as a state trooper for too many years, perhaps, do you think that there will be more stops, in particular of younger people, than there would have been in the past? And the only reason I raise that question is because if it's an ounce or under, they really don't have to worry about the reason for the stop, because no evidence can be suppressed because it's not a constitutional violation. It's nothing more than a civil penalty, so to speak.
Well, I think the vast majority of stops are based on some sort of motor vehicle violation in the first place. Very
I
rarely
agree
would you
with
be
that.
driving along and see someone, although it happens frequently enough, more than you think, of just driving along and see someone smoking and pull them over for that. And of course, you could never mistake it for a cigarette. If you
Right.
happen to make a mistake that you said, well, I thought they were smoking a joint and it happened to be a cigarette, that would be a grounds for dismiss for suppression.
Suppression, right,
But
right.
now you're right. I mean, you say they thought it was marijuana. I pulled them over. There's no suppression issue anymore because it's not criminal.
As long as it's
As long as
under an ounce.
As long as it's
An
under an ounce,
ounce or under, yeah.
the fact that you were apprehended as a result of potential, I suppose, an unlawful stop is not going to be an issue.
Yeah.
The fact is, they caught you with it. The possession was there, and unless unless someone brings it to an appellate level somehow, and right now with the way the law is written, magistrate, if you do appeal it, really that's not a magistrate's decision necessarily to make. It's one of those problems that the authors didn't contemplate when they wrote this whole thing.
Right.
So I don't think younger people will be targeted any more or less now. It's certainly going to be a lot less cumbersome for police. Rather than arresting an individual for possession of marijuana and in the time it involves to do that, they can easily write out a citation. It could be a revenue enhancer for cities and towns.
Right,
Who
that's for
knows?
sure. I was going to mention that. The fines actually go to the towns, which in the past wasn't necessarily the case. It would go to the state in
It would
many
go
cases.
to go to the state.
Criminal,
So
yeah.
there was no fine for first offense,
Right,
and the
right.
subsequent offenses would usually go to the state. Now, even if state police catch a person in, say, Westford, Westford is going to put on
Benefit
the
from
citation.
that.
Westford as the clerk of the town who will be responsible for collecting that fee. Certain
Which-
areas may benefit more than others.
Which are some of the other areas that we haven't necessarily covered, but there are still questions as to who's going to track this, who's going to collect the fees. I guess we know where they're going to go, but we're not totally sure who's going to do the collecting and who's going to do the future punishment if the courses are not taken and so on and so forth, where the court system used to do all of this before. Court system is pretty much out of it now.
Except for the appeal, if the person wants
Except for the appeal, right.
wants to challenge, and even that, the challenge of it, like I said, the standard of proof is so low now that the challenge is almost not worth the effort. Take the time off for a $100 fine.
Right, right.
I don't see what you gain by it. You can't. Your defense is not. There's not much of a defense you can raise.
Well, Jerry, I want to thank you again. This a half hour has gone by really quickly, and this has been a subject of important to cover, given the contemporaneous vote that we took in November. I know that we're going to have to do another one, because I know that the committee that you're on, which is the Executive Office of Public Safety Committee, studying all of this, along with a lot of other departments, are going to be making recommendations. And I know the legislature is going to get into it, and we're probably looking 6 months down the road for all of this to happen.
Yes.
But eventually this law will change a little bit. I want to thank you all for watching again. I want to thank Jerry for coming on.
Welcome.
And we will see you again next time.